All of this started with Windsor, which was a U.S. Supreme Court case last year. And within weeks of that ruling, I filed a case here in Ohio seeking marriage recognition on behalf of two people, one of whom was dying. And they wanted their dying partner's death certificate to reflect their marriage, because on every death certificate it says married, and there's a box, and you say yes or no, and it says surviving spouse. And they were married. They had been married in Maryland. And so this was a very important affirmation of their life together, of their commitment to each other, and of their place in our civil society if we're going to let this happen. So the judge then ruled that indeed, under the Windsor case, Ohio should recognize their marriage. We added another couple who had just had a tragic death of his partner, and a funeral director who had standing to represent other people who were dying and dead. So that order is permanent. That order says Ohio must recognize the marriages of these people, and that's on appeal now in the Sixth Circuit Court of Appeals. What we will do as people who need death certificates come up, we will just go back into court and get them. Later, we filed another case involving birth certificates. That's the Henry case. We represent 4 couples, and they all said they want their marriages from other states recognized by Ohio for the purpose of having both of their names on their birth certificates. 3 of those couples are pregnant. One of the first one's due in May, and if they had been opposite sex couples, both their names would go on the birth certificate, even though they've used artificial insemination, because they have an anonymous donor. And because they're same-sex couples, Ohio does not recognize their marriage, won't let their union be recognized on the birth certificate, and the court has ordered that those couples now all have their names recognized jointly on the birth certificates of their children. One couple has an adoption decree from New York. The adoption decree says Joe and Rob are the parents of their child. And the adoption decree also says all of their relationships, their relationship as parent and child, will be recognized on their birth certificate. New York sent that adoption decree to Ohio, and Ohio refused to put their names on the birth certificate, the revised birth certificate for the adopted child. And now the court has said, you need to do that. You need to do that, Ohio, because you must recognize this New York marriage and this New York decree. So that's where we stand on those 2 cases. Oh, I don't know which state. We've now had 10 district courts rule either that marriage should be celebrated in the states that have been sued, and or that their marriages from other states should be recognized. And they've been unanimous rulings. All of them have said that the Windsor case set a precedent that must be followed, and that there's a fundamental right to marry, and that the Equal Protection Clause requires that these various states honor the marriages and these proposed marriages. They're all on their way to the Supreme Court. The Fourth Circuit argument is May 9th. The 10th Circuit argument from Oklahoma and Utah was argued last week. We don't have an argument set yet, but our briefs are being filed. The state's already filed the brief in Obergefell. Our brief is due shortly, so we'll get an argument pretty soon. Tennessee, Kentucky, and Michigan have all had marriage cases, same-sex marriage cases. They're all in the Sixth Circuit Court of Appeals. One of them will go up to the U.S. Supreme Court. It's all very moving. I mean, and it all is sort of absurd. I mean, think about the 4 couples in the Henry case. You have one person there who the state's saying, we won't let you be on the birth certificate, but that person is the parent. And that person's saying, sue me for child support if I screw up. Call me if my kid is truant. Make sure my kid does a good job, and call me if they're delinquent and we need to discipline them. And the state's saying, no, you can't have that responsibility. I mean, this makes absolutely no sense, especially in an era when we are eager to make sure that we don't have deadbeat parents, that we don't have parents who neglect their responsibilities, that we do have two-parent families whenever possible. This makes totally no sense. And for that reason alone, I think that it's backwards. And I think that Ohio should be embarrassed for fighting these loving couples in their efforts to secure justice. And in the Obergefell case, I mean, who can deny someone the recognition of their marriage on their death certificate? I mean, what skin is it off the back of anyone in the state? In fact, there are 17 states and the District of Columbia that permit gay marriages. I mean, we're going to be seeing this day in and day out, where people travel to the border of Ohio, cross in. They can't lose their marriage when that happens. That's just not acceptable.